And camera, where's the camera? Is it on the TV? Okay. Good morning, everyone. This is Judge Smith, Jared Smith, and we are out of Orlando this morning on the only case that we're having this morning by Zoom, which is 23-3946. Again, I've introduced myself. Let me introduce my colleagues. To my right is Judge Petra Brownlee. To my left is Judge Brian Lambert. And we will proceed at this point. Mr. De La Molina, can you hear me okay?
Yeah, Your Honor.
Okay. And Mr. De Molina, we have 20 minutes per side. So what we ask folks at the beginning is, how much time would you like to reserve, if any, for a rebuttal argument? So you can take some of that 20 minutes if you want to, and reserve some for rebuttal after you hear Ms. Montezuma's side presented. Would you like to reserve any time for rebuttal?
Yes, Your Honor. Please, for the first time, I need 14 minutes. For the review, that's 6 minutes.
Okay. All right. Timekeepers have that? Okay, excellent. Okay, so just watch your clock. We'll go ahead and adjust that to 14 minutes and let you know when that's up. And I'll try to find a stopping point, and then we'll switch it over to Ms. Montezuma. So with that, you may begin, Mr. De Molina.
Thank you, Your Honor. Well, good morning, Your Honors. My name is Carlos de la Melena from Peru, and I am the left behind father in this case. Today, I am representing myself in this appeal to seek the return of my daughter to Peru under the Hague Convention on the civil aspect of international child abduction. This case involves Peruvian citizens. All parties, my daughter, the mother, and myself, are Peruvian. None of us hold American citizenship. The case began on December 8, 2022, when I filed the petition for the return of my daughter to Peru. Your Honors, I am not asking for equitable tolling in this case. I am simply stating that I filed the petition for my daughter return within the 1-year period required by the Hague Convention. Therefore, her return to Peru is mandatory under Article 12 of the Convention. Legal precedents support this position in cases such as Zucker versus Andrew, Riley versus Gooch, and Blank versus Morgan. The standard is clear. Wrongful retention begins when the left behind parents ask for the return of the child and the other parent refuses. In my case, the mother first informed me of her decision to remain in the US permanently on December 8, 2021, correct. During the trial, I specifically asked the mother, why did you wait until December 8, 2021 to tell me? Her response was, because I didn't want the father reaction to interfere with my daughter adaptation process. Your Honor, you can find this on transcript page 936, lines 70 until 23. This exchange makes it clear that I had not knowledge before December 8, 2021, that my daughter would not be returning to Peru. Up until that point, I had agreed to a temporary extension of the trip. The mother, however, had secretly made plans to stay in the US and had concealed my daughter's whereabouts. The trial court erred by concluding the wrongful retention began on October 3rd, 2021, when the travel permit expired. This decision overlooked the mother's own testimony, in which she confirmed that she did not inform me before December 8, 2021. On her intention to stay in the US, the court acknowledged that we had agreed to a trip extension, but they inconsistently used the permit expiration date to establish wrongful retention. Additionally, the court misinterpreted a key conversation between the mother and me. It focused on my reference to a US option without considering the full context. In the reply brief, page 9 and 12, I expressed concern about my daughter staying in the US for too long, stating that she could face issues if she stayed longer than 6 months, as she was on a tourist visa. This conversation was part of the extended trip and clearly understood that my daughter would return to Peru within 6 months. This reinforced that I never consent to a permanent stay. Furthermore, cases like Cabrera versus Lozano and Mendez-Lynch versus Mendez-Lynch emphasize that the court should not reward parents who conceal their child location. as it undermines the very purpose of the Hague Convention. In my case, the mother actively concealed my daughter's location, and there was no way for me to know before December 8, 2021, that she intended to stay permanently. Your Honors, my second argument is that the trial court failed to fully consider the mother's testimony and crucial evidence. This is not just about ignoring certain estimates, it's about disregarding clear admission by the mother that are central to this case. During the trial, the mother admitted several times that she concealed my daughter's whereabouts and that she made secretive and primitive decisions without my knowledge or consent. In the transcript on page 935, lines 20 until 24, she confirmed that she wanted to extend the trip without informing me of her true intention. On the transcript, page 936, line 9 until 10, and lines 22 until 23, she stated repeatedly, "I didn't want the father's reaction to interfere with my daughter's adoption process." One of the most critical pieces of the evidence is a WhatsApp conversation between mother and me, which was presented as supplement record exhibit number 5. In this conversation, on page 9 of the reply brief, I asked the mother if our daughter would have any problem leaving the US or returning to Peru. The mother responded, "No, because she has 6 months." This exchange showed that we were still discussing to the extension of the trip, under the assumption that our daughter's stay will not exceed 6 months. This is key because it demonstrates that I believe the maximum stay in the US will be 6 months, not permanent. As the trial court concludes, the court incorrectly interpreted the situation as having not set time limit, when in reality, the 6-month tourist visa was the clear boundary of the trip extension. The mother had enrolled our daughter in a school in October 2021 without telling me. If I had been aware of her permanent plans, I would not have agreed to the extension. The mother action, hiding my daughter's location and her true intention, are exactly the type of the conduct that the Hague Convention was designed to prevent. The mother's own admission confirmed that the wrongful retention did not occur until December 8, 2021, when she finally told me of her plans. Your Honor, the misinterpretation of the wrongful retention began, and the overlooking of key testimony led to misapplication of the Article 12 of the Hague Convention. Article 12 is clear. If the petition for return is filed within 1 year of the wrongful retention, the return of the child is mandatory. No exception, such as well-settled defense or child maturity consideration, apply within the first year. Since I filed my petition within the 1 year period, my daughter's return to Peru is mandatory under the convention. The mother attempt to use the well-settled defense or any other exception is a clear example of abusing the provision of the convention to delay the return of my child. The trial court failure to acknowledge that I filed within the first year allowing the mother to benefit from the wrongful action, which is precisely what the Hague Convention seeks to prevent. Finally, Your Honors, I want to address forum shopping. The mother action, hiding my daughter's whereabouts and initiating for legal process in Peru, were deliberately designed to delay the process and create a defense based on child being well settled in the US. The mother action showed that she is premeditative her move to the US, and she has attempted to use the legal system to her advantage by creating favorable circumstances in the US court, despite her violation of my rights under Peruvian law. Your Honor, for all the above exposed, the court should reverse the lower court decision, and thank you. I have finished this part.
Mr. De La Molina, there may be other questions from the panel, but I've read the messages that you're referring to. I understand that there are probably a couple ways that these could be read. And my question to you is, where in these WhatsApp messages that we have in the record, the ones from October 18, well, I guess it's even longer than that, but we'll just go from October 18 to, well, pretty much that entire day, maybe through October 20th. Where in those messages do you see any sort of assurance that your former wife, Ms. Montezuma, is actually going to return to Peru with your daughter? Point me in these messages where there's any assurance that she's actually going to come back.
Well, Your Honor, in the exhibit number 5, the conversation, the WhatsApp conversation, okay?
Tell me the date and time if you could, because I've got it by record page numbers, page 1620 through 1623 or so. But if you could just even tell me the exact time it is, and I can probably locate it if you give me the minutes. Most of them are organized by minutes.
Okay, Your Honor. The date is October 18, 2021, and the time is 7:43
Okay.
p.m. The mother respond no, because they gave us 6 months. And previously in the 7:41 p.m., I asked, won't you have problem when you want to leave or come back?
Okay. Anything else?
Yes, Your Honor. Okay, and other part in 7:49 p.m., I asked, but about extending me a trip is this. Yeah, and I put how long is it? And is around 4 months or more, or you don't know? I mean less than 6 months, because after that you have to leave. And the mother respond, sure.
Okay, and so I read that statement, Mr. De La Molina, where you said to her, but about extending Mia's trip, how long is it? Or is it around 4 months more? Or you don't know? I mean, less than 6 months, because after that you have to leave. And all her response is sure. She doesn't say 6 months. She doesn't say 4 months. She doesn't say more than 4 months. She just says sure. And so my challenge is that you've got so many other statements that are present here where she says she's going to move at 7:47 p.m. It means starting to move. She says she doesn't have an alternate plan. She tells you around the time when you all are discussing child support and your inability to pay child support, that the school overwhelms me. And then you both talk about how schools in America are cheaper. And these statements, and she's opening bank accounts and she's talking to an immigration attorney. How would that not indicate to you at this point in time that you have a problem here? That your wife is literally, she's not just saying that she's going to visit America. She's making plans of getting a job, staying, moving, opening bank accounts, talking to immigration attorneys. How would you not interpret that to mean that your wife is going to stay in America with your daughter?
Well, Your Honor, because we were under the assumption my daughter entered with a tourist visa and went to school in Peru, in that moment. And opening a bank account is usual practice for a mother owns a company in Peru, and my daughter had a tourist visa, and she's not an American citizen, and no one in my family is. And since the pandemic, looking for a job remotely is also common practice.
But why would that require immigration attorneys to look for a remote job?
Really, Your Honor, I think for her company, because she wanted to open an account for her company, and I really, I don't, I don't know really.
Okay. I was curious what you meant, because when she's made the mention about moving, your response was, be careful, I don't want to burst your bubble, but you know that the USA is about to face problems in China too. Why would you be concerned about the USA facing problems if you know she's coming back?
About the bank accounts is she want to move her money in the USA.
She wasn't talking about bank accounts though at that time. At that time, she was talking about moving, like physical move.
Well, in part, the WhatsApp is an informal conversation, Your Honor. I mix many times or many themes in the conversation.
Okay. Does anybody else have any other questions?
Sir, I heard you state, am I correct, that you believe you were giving her an extension of time to stay in the United States and it's nothing more than an extension?
Yes, Your Honor.
Can you tell me where in the record or what the date of that extension is? How long was that supposed to last? Is there something in the record before us that tells us the date where that extension would expire?
Well, in the record is in the conversation, the Exhibit 5, the supplementary record, the Exhibit 5, the whole conversation is about the extension trip, and I said about you need to return the Peru or the country in less 6 months. Is the limit time. Your Honor, because
you are into your rebuttal time. If you want to stop now so that you can
yes,
save some time for rebuttal,
yeah,
we'll let
please,
you.
Your Honor.
Okay, thank you. Thank you. Okay, counsel, you may proceed. And
May it
you
please-
could announce your name for the record, please, as well.
Yes, Your Honor. May it please the court, Catherine Rodriguez, on behalf of the appellee, Joanna Montezuma. Your Honors, the standard of review here are questions of fact, so it's clear error under Minoski v. Taglieri, the Supreme Court case, as well as Calixto v. Lesmes and Wigley v. Harris. It's deferential to the trier of fact. I'd like to jump off Judge Brownlee's question about a specific extension. There was no specific extension, Your Honors, ever given in this case. And the case law on Hague Convention cases and the retention always revert down back to the date of agreed upon return originally when there was an agreed upon return date.
Counsel, if I could pause you just for a second, because standard review definitely is something that is an issue on this one. You had testimony in the lower court, but largely it appears that the ruling was based on these WhatsApp communications. Why wouldn't we be able to look at that de novo based on the case law that says we essentially use a split standard when we have text messages or videos that we can evaluate versus testimony if we can look down and essentially tell which one the trial court was most heavily relying upon. So would that take us out of the clear error standard? Do you have did you come here with a thought to that effect? Because that was definitely something that at least I was concerned about.
That's a good question, Your Honor. And it's Judge Smith. If you look to the case law with respect to Hague Convention cases, the application of the Hague to the facts can be a de novo when you're interpreting the Hague Convention. However, the determination of a retention date is a fact-specific inquiry. So, for example, Your Honor, in Taglieri in the Supreme Court, the test that there was a split within the circuits regarding the habitual residence, that was a de novo review. What is our test? Is it a shared intent or is it a totality of the circumstances? They resolved that. So when applying the test from the Hague Convention, that would be de novo. But when looking at what is the habitual residence and the facts to support that, that would be a deferential abuse of discretion. So too here, Your Honor.
Counsel, was there testimony from the parties at this hearing discussing their intent or their interpretation of what they sent in their WhatsApp communications?
My recollection, Your Honor, was the discussion was going through the WhatsApps and what was being discussed and communicated to Mr. Della Melena by my client
So
during
your
the trial.
Your client testified, this is what I meant when I said that, and Mr. Della Melena also testified. So did the court then, the trial court had the ability to evaluate the credibility of that testimony vis-a-vis the WhatsApp communications?
Your Honor, as I stand here
I'd
today,
have thought your answer would have been yes, but go ahead.
Yeah, Your Honor, I don't recall whether that specific question was asked in the transcript. I do recall that in the transcript, the client was running through what was said during the trial. What happened in the transcript was there was obfuscation. There's always obfuscation in these hate cases. But
What Judge Smith is saying is, you know, we can read the same things that the trial judge read. So there's no reason for us to give deference to the trial judge's interpretation of the same written documents. But that's a little different if it's unclear what was really being intended, which seems to be the theme, at least a part about your opponent saying, look, we never intended for them to stay past the October 23 date. So the trial judge would have heard testimony about that in the context, because the WhatsApp information is kind of the springboard to the trial court's determination as to when the child was retained here in the United States, right?
Yes, Your Honor. And the testimony that was elicited was, as I recall the testimony as I stand here, was my client was under the impression he understood by their conversations that they were staying, but it was not clear.
By their conversation, did they talk about it as well over and above their WhatsApp communication?
No, Your Honor, that did not come out in the trial.
But let me ask you differently. On page 36 of your brief, footnote 3, you say, while the trial court referenced that the 1 year, this is talking about the affirmative defense, is applied to both the well-settled defense and mature child objection defense, the 1 year is only a condition to the well-settled defense. Let me make sure I'm reading that correctly. So if within the first year, let's use October 23 as the date, and let's say Mr. Della Melena had filed his petition before October 23 of 2022. Do I read this footnote to mean that if a mature child testifies that I do not want to go back to the originating country, in this case Peru, that would still override you have to return the child within 1 year if it's timely brought and the other conditions are met?
That is correct, Your Honor.
That's what your footnote is telling me.
That is correct, Your Honor.
Okay, and the case law, is there case law that says that, or that's in the specific language of the, you cite to Articles 12 and 13 Hague Convention?
Yes, Your Honor. If the court reads the Articles 12 and 13, the only applicable defense to the 1 year is the well-settled defense, and the case law regarding Hague Conventions is very clear. 1 year has no applicability to any other of the enumerated defenses within the
Well,
Hague.
let me follow up on that, just so again, I'm understanding what you're telling me in your briefing and your argument today. So in other words, let's say that, I know the trial judge found it was past 1 year when this petition was filed. Let's assume, for the sake of my question here, the petition was filed within 1 year, no ifs, ands, or buts. Your position, if I understand it, is that if the mature child testifies, I don't want to go back to, in this case, Peru, and gives reasons for it, and the judge finds that persuasive or meets the evidentiary burden of proof, that the trial judge would be within her or his right to say, well, I know you timely filed and I know this, but this mature child objection allows me to deny the petition, and that's what I'm going to do. And assuming that's based on substantial competent evidence, that would be an affirmable order. Is that your position?
Yes, Your Honor.
Okay.
Do you think that that was the trial judge's understanding in this case upon review of her order?
No, Your Honor, that doesn't appear to be her understanding, based on the review of the order. However, she did find the mature child objection. She didn't have to have the 1 year. So it is, the mature child objection was proven, and the 1 year was not required with respect to that. So the entirety of Mr. Della Melena's argument about retention has no applicability to the court's finding about the mature child objection, Your
And
Honor.
similarly, then, if the trial court erred in the determination of the well-settled affirmative defense, and I'm not saying one way or another, I'm saying, again, hypothetically, for the purpose of this question, if we found that to be error, your view would still be that there was evidence to support the trial court's finding, competent substantial evidence to support the trial court's finding of the mature child objection, and it would be affirmable on that basis alone, and any of the other reasons espoused here for reversal are immaterial. Is that a fair route to look at this case as well from your argument?
Yes, Your Honor.
All right.
It is. And
ahead.
the mature child objection is a factual determination, and it's, again, clear error, standard is deferential to the trial court.
The mature child objection, was that based primarily, I mean, I understand the child didn't testify, but it was based primarily on Dr. Is it Furpey's testimony and evaluation?
Yes, Your Honor.
Okay. The issue raised by your opponent is that one of the issues is that his testimony, the doctor's testimony, did not qualify under Daubert's standard. Let me ask, I'm dating myself here. In the old days, when we were under the Frye standard, we would have what were called Frye hearings, which were certainly entertaining in their own right back in the day. But that being said, we've passed Frye. So was there an actual request for a Daubert hearing? And if so, was it conducted here?
There was no request for a Daubert hearing prior to the trial, Your Honor. That is required under the case law, but even giving Mr. Della Melena the benefit of the doubt, the Daubert would not exclude Dr. Furpey's testimony. The Daubert, and yes, I remember the Frye hearings as well, Your Honor. The Frye standard that was replaced in 2013 with the Daubert standard, then repealed in 2018 briefly, and then reinstated in 2019, is a flexible approach, and it doesn't exclude all testimony simply because you can't do a scientific test. And in the Andrews v. State case, which I cited to, psychological and psychiatric testimony cannot follow rigid tests.
I'm sorry,
And
you said Andrews v. State?
Andrews v. State, yes, Your Honor.
That's from the 50s here, right?
Yes, Your Honor.
Oh, what are they now?
So it isn't a rigid checklist. That's what the U.S. Supreme Court has said in U.S. v. Brown and in Daubert and in Kumho Tire. The court is the gatekeeper, is the trier of fact, has to look at the credentials. Dr. Furpey's credentials are impeccable. He's a Princeton educated, Sorbonne educated psychological expert who was qualified in both state and federal courts.
Let me ask this before I shoot myself in the proverbial foot. I wasn't actually on that opinion in Andrews, was I?
You know what, Your
I
Honor?
hate to be arguing against something I thought was a good idea way back when. but-
I have it in my book, but I don't want to look away from the camera. I don't recall, but I do use that opinion quite often.
I found it. Lawson wrote it. Okay. He's a smart guy. Cohen and Berger. So, all right. So it was that court. I was on that court, but I wasn't on that case. So I'm free to criticize.
Well, it's been a helpful decision because, as you know,
For you, yeah, it's very helpful for your side. Yes.
well, in family cases, we have psychological experts and we don't have rigid checklists. This isn't a tire case where you can do a tire test. It is not a pharmaceutical case with very specific scientific tests. Psychological and psychiatric testimony is necessarily has to be utilized different standards. And the drafters of the Hague Convention didn't give a specific test to utilize. And therefore, again, it goes back to the trier of fact deference to the trier of fact in determining credibility and weighing the testimony.
Was this, counsel, was the specific argument that Dr. Furpey wouldn't satisfy the Daubert standard made to the trial judge? Or principally was the argument before the trial judge that Dr. Furpey was not a neutral party because supposedly he was retained by the mother, although my understanding is that he was court appointed?
You are correct, Your Honor. He was court appointed. There was a lot of argument in the trial court, one about him, yes, not being neutral, but Mr. Della Molena was also permitted to cross-examine Dr. Furpey on numerous Google reviews where a dissatisfied family advocates have posted nasty things about him, saying he also wasn't qualified. So I believe Mr. Della Molena gave a vigorous cross-examination of Dr. Furpey, but he was a neutral, Your Honor. And in the record also were communications without myself being copied to Mr. Della Molena, asking him to please respond. Dr. Furpey was present for most of the trial. He had to go to an emergency hearing, but he did review Mr. Della Molena's materials, and it did not change his opinion with respect to the maturity of the child objecting, as well as the child being well settled. That second prong after you reach the 1 year, that she was well settled and met the seven prongs of the Lozano decision in the Second Circuit, and also articulated in Tavares
Let me
regarding
ask,
what.
was there, excuse me, was there a specific objection raised by your opponent to the trial court that Dr. Furpey was not qualified to testify? In other words, based on his background, experience, or lack thereof, he was not a qualified expert to testify in the field in which he testified before the court.
I don't recall that, Your Honor. I read the transcript several times in preparation for today, and I don't recall him challenging the qualifications. I recall him challenging the methodology, presenting his own expert testimony, and
Because there was
challenging.
testimony that this doctor had testified as an expert in Hague Convention cases, if I understand, in both federal court and state court.
Yes,
So
Your Honor.
This doctor had been previously qualified by many other judges in this field
Yes, Your Honor.
prior to testifying at this trial in this case.
Correct, Your Honor. Dr. Furpey testifies in many Hague cases. And did so in this case. And I would note, I also in the record, Mr. Della Molena, his prior counsel, as well as Mr. Della Molena, we gave 3 names, and Dr. Furpey was arrived upon. Mr. Della Molena then found the Google reviews and then objected to him being the
So when he was
court-appointed.
when your opponent was represented by counsel, of the 3 names, this was the agreed upon name to do the evaluation?
There was never an agreed upon name, Your Honor. With prior counsel, I sent her 3 names. She said she would look at them. She had a series, her husband was apparently put in hospice, is my understanding, and she had to withdraw in April. I never got a response to that. Once Mr. Della Molena requested a status hearing, it was given immediately to him. I filed the email I sent to the council so that the court could see that I did not delay. I represented at the January 19th order to show cause hearing that I would confer with counsel at that hearing. There was a tentative agreement to get a guardian at that time, and discussion of evaluator. They're both used in these Hague Convention cases. In state court and federal court, the judges just appoint evaluators.
Could you address the argument that Mr. Della Molena raised about the exclusion of, I guess, certain translated information that the trial court, I guess, excluded because it was not translated with a certified translator?
Yes, Your Honor.
Could you tell me how that arose and the discussions at the trial court level about that?
Yes, Your Honor. There was a pretrial order. We exchanged exhibits. I filed an objection in August to Mr. Della Molena's proposed WhatsApp exhibits because it wasn't a certified translation. Mr. Della Molena did not get the certified translation and chose to proceed without them. while the Hague Convention provides for relaxed rules of evidence, it does not state that you just waive any requirements within the state. For example, hearsay. Some courts will waive hearsay to a certain degree in Hague cases because of the relaxed rules. Mr. Della Molina opposed that. However, it does not change the Florida state law that requires translations to be official, Your Honor. In Yanas versus State, a second DCA case, the court was reversed for allowing someone to read a Spanish translation, but was not a certified translator, because the rationale would be obvious that people that don't speak the language cannot tell if it's being translated accurately. Mr. Della Molina was aware of my objection and could have easily corrected it, but chose not to. Other cases I cited are Ortega v. State and Hutchins v. State. These documents were not excluded based on authentication, which is what ICARA, the International Child Abductions Remedies Act, the implementing federal statute for the Hague Convention, requires no authentication, but the translation of documents still needs to be made by a certified translator so that we have some integrity in the translation of the documents. And the Hague Convention itself contemplates that there will be translations and specifies the language to utilize.
Counsel, am I correct? Are you speaking of the same ones where all of these conversations came in any event through your side? And if we are talking about the same documents, are any left out such that there was something that he tried to put before the court that did not come in through your side?
Your Honor is correct. Most of the conversations did come in through our certified translations. The only WhatsApp that did not come in was the December 8th, 2021, where Mr. Della Molina alleges that that's when he became aware for the first time that she was not returning. However, under the plethora of case law, the fact that he became aware is irrelevant. Under Dimaj versus Sakaj, Velasquez versus Green, it reverts back to the agreed upon date when there was an agreed upon date. He was also able to cross-examine my client quite vigorously, as Mr. Della Molina argues that that was the date that he claims he understood, despite the very clear WhatsApp conversations regarding the things that Your Honor's brought up, the immigration, the bank accounts, him saying the U.S. option involves moving completely, cited in the order denying return that the court found was the most persuasive.
But counsel, am I correct though that the December 8th date would be relevant if he's correct that the extension went through December 8th? Doesn't then that become under that part 2 of the test, or the or part of the test rather, that date would become relevant if his assertion to us is I gave her an extension of time through December 8th?
No, Your Honor, respectfully no, because it would have needed to be, as Your Honor's previously noted, there was never a specific agreed upon extension. There was an agreed upon date of return, and under all the case law on retention, without a specific extension date, which there never was, and it was amorphous at best, it always reverts back to the previous agreed upon date of return. And his own case, Your Honor, the Zucker case, the same thing. The father says, oh, I didn't realize until July that they weren't returning, but the court said that's not reasonable. It's February, she moved into her own apartment. That's not reasonable. So when someone realizes or claims this is when I had the aha moment, they weren't returning, that is not the relevant inquiry when you had a prior agreed upon date of return. The Perez-Vieira report cited by the Supreme Court and numerous case law, the explanatory report to the Hague says when there is an agreed upon date of return, that is the date utilized for the retention, not when they realize. Otherwise, they would have put the words discovery into the Hague Convention, and they did not.
Thank you.
Any other further questions? Okay, thank you, counsel.
Thank you, Your Honor.
Mr. De Molina, you may begin, and if you need an extra minute and a half, we will give that to you because we let your opposing party go a little bit over there. Okay?
Okay, thank you, Your Honor. Well, Your Honors, the mother entered the U.S. with our daughter on a tourist visa in September 2021. Under the terms of that visa, her stay could not exceed 6 months. We had discussed a temporary extension when on December 8, 2021, she told me for the first time that she intended to stay permanently. This is clearly demonstrate that I believe the state was temporary and will not exceed the tourist visa limit. It also showed that the wrongful retention could not have occurred before December 8, 2021, as I had no reason to believe that the mother planned to stay beyond the authorized period. And remember, Your Honors, I trust the mother, my daughter always come back to Peru. When the mother said sure to my question of the 4 or 6 months, it was normal. Moreover, there are 4 ongoing custody cases in Peru, further establishing that Peru retains jurisdiction over these matters. The mother conduct concealing her intent to stay permanently demonstrate premeditation, Your Honors. She abused the extended trip to remain in the US and violated my parental right by refusing to return with our daughter when asked. And Your Honors, I am not debating that Dr. Firpi lacks methodology and data. I argue the fact that the trial court gave undue weight to bias investigation and did not analyze to whole context. Under the Hague Convention, the rules of admissibility are relaxed, but relaxed does not mean that the trial court abused its discretion and completely considered absolute truth Dr. Firpi's testimony. And again, the petition was filed during the 1-year period.
Let me, Mr. Lynch, so are you saying you're not contesting the qualifications of Dr. Firpi? You just believe that the trial court gave his testimony way too much weight and credibility. Is that what you're saying?
Because, Your Honor, the rules are relaxed, correct, Your Honor.
Okay.
Your Honor, the Hague Convention mandates the immediate return of the child if the petition is filed within 1 year of the wrongful retention. As I filed my petition within this period, the return of my daughter is mandatory and the well-settled defense does not apply. The trial court rewarded the mother's wrongful conduct by allowing her to stay beyond the permitted time and override Peru jurisdiction. This is precisely the kind of behavior that the Hague Convention was designed to prevent. According to the Elisa Perez Vera report, the exception to the rule concerning the return of the child must be applied only in a restrictive way. If not, the convention will become a dead letter. In fact, the convention as whole rests upon the unanimous rejection of this phenomenon of illegal child removal and upon the conviction that the best way to combat them and at the international level is to refuse to grant them legal recognition. I request that this court reverse the trial court decision and order the return of my daughter to Peru, Your Honors. I finish, Your Honor.
So, Mr. De Molina, I'm just going to give you one last chance to respond to this. I raised this before, but I just see this so many times mentioned in this conversation back and forth in WhatsApp. And I'm looking at it once again, where you are talking about the price of school in the United States. And you yourself said schools are cheap there. Yes, indeed. How could your child attend school in the United States, a cheap school in the United States, and yet not stay in the United States?
Well, first, Your Honor, I trust the mother. I gave multiple travel permits. Yes, it was an informal conversation, and she was attending a school in Peru in this moment. And the regular period, the scholarship in Peru is December, up to December. And
okay, fair enough.
Okay.
I appreciate that. Any other questions from the panel? Thank you so much, both of you. Appreciate it. And I would tell you that, we're going, just Mr. De Molina, so you understand the process. We confer as judges and we will issue an opinion. Honestly, it doesn't prevent the two of you from picking up the phone and having a conversation. I'm going to tell you the same thing I would tell somebody in my family law court. Doesn't prevent the two of you from picking up the phone and having a conversation and taking this decision out of our hands. You all have the power to do that at any point. And I always say it's better for parents to make decisions than courts to make decisions. I realize we're way down the road on that. But it's never too late for you all to take that out. All you'd have to do is if you'll reach an agreement, you can notice that this is dismissed. But otherwise, we will confer and we will frankly promptly probably issue a decision on this because of all that's going on with it. Okay, so thank you so much. Nice meeting you both. Take care.
Thank you, Your Honor.
Your Honor.